4, 3, 2, 1.
This Honorable Court of Appeals of Tennessee is in session.
Good afternoon, Council. Before we call the case, just a brief reminder that while we don't anticipate any technology-related problems, always can happen. So if we should have any, everybody just take a deep breath and pause, and our tech people or tech experts will get us back on and get us up going again. Call the case, please.
Barry Vaulton et al. Versus Polaris Industries, Inc. et al.
We'll hear from the appellate.
May it please the court, my name is Chris Kane and I represent the plaintiff appellants Sam Barry and Joy Vaulton. I'd like to reserve 3 minutes for rebuttal.
Yes, sir.
On September 1 of 2016, defendant Ritchie took possession of and received from the defendant manufacturer Polaris a 2017 ATV known as the General. On November 26 of 2016, the Vaultons purchased that ATV, the General, from Ritchie. On December 3rd of 2016, the Vaultons took possession of that ATV. And on March 7th, 2017, 14-year-old Sam Vaulton was operating the General. He noticed that the hook on the winch appeared to be stuck. He put his right index finger around the hook and asked a friend to push the out button on the winch controls to release the cable out. Unfortunately, the steel cable retracted, jerking the hook and Sam's finger into the winch's metal rollers, severing Sam's index finger. The Vaultons brought suit alleging that Ritchie was negligent in failing to have a tether strap attached to the winch at the time the Vaultons took possession of the General. They also alleged that Ritchie was negligent in failing to provide them with an owner's manual or safety instructions, particularly regarding how to operate the winch. They alleged that the General was defective or unreasonably dangerous because the winch cables reverse spooled, pulling in regardless of which directional button was pushed, and that the General was defective or unreasonably dangerous because Polaris failed to provide a rubber safety stop to prevent the winch hook from being pulled into the metal rollers. Polaris and Ritchie each filed summary judgment motions, and on April 19th of 2021, the trial court entered an order granting summary judgment in favor of both defendants. Respectfully, the trial court erred in doing so. Specifically, the trial court ignored and failed to even acknowledge the plaintiff's evidence on all 4 of those issues. And as a result, the trial court erred in all respects in granting summary judgment to the defendants. I want to first talk about the Ritchie defendant. And the trial court, as a matter of law, found that a tether strap was in place at the time of delivery to Ritchie and remained on the equipment until it was purchased. And that's on page 2 of the trial court's order. Now, respectfully, the issue is not whether there was a tether strap in place at the time Ritchie took delivery or when the Vaultons purchased it. The issue is whether there was a tether strap at the time the Vaultons took possession of the vehicle, of the ATV. And on that issue, the record demonstrates that the plaintiffs, and this is the testimony in the record, plaintiffs never saw a tether strap. Sam Vaulton testified that no tether strap was attached to the winch. And the day of the accident was the first time the Vaultons had used the winch. It had never been used before. Ritchie's
Counsel, I'm sorry to interrupt you early, but Mr. Vaulton, what was his testimony about the tether strap?
Which Mr. Vaulton, Sam or
the
father, Barry?
Father.
father testified he never saw a tether strap on the ATV.
Did he say that there wasn't one?
He did not say that specifically, no.
And didn't he say that if he had seen that there wasn't one, he would have insisted that one be put on it?
Yes, he did testify to that, Your Honor.
Where's the testimony that he said that there wasn't one on it?
He said his testimony was that he never saw a tether strap on it. And that if it had been, he didn't look, I guess, apparently. I mean, or look, he didn't inspect it for that purpose, but he never saw a tether strap on it.
All right.
The day of the accident was the first time that the winch had been used. Richie's mechanic, Mr. Packleb, and his testimony is in the record, could not say whether a tether strap was attached to the winch at the time the Vaultons took possession. The same gentleman conceded that he did not know if the tether strap fell off or was removed prior to the Vaultons taking possession. Lacey Coker, a sales rep for Richie, testified she didn't know whether there was a tether on the whether there was a tether at the time the Vaultons took delivery. Sam testified, the young man, that he was familiar with tether straps, and if one had been on present, he would have used it. And finally, the tether strap was missing on November 18th, 2018, the date of the first inspection by the defendants, and that was 20 months after the accident. Yes, after the accident. In sum, there's certainly a factual dispute as to whether this ATV had a tether strap on it at the time the Vaultons took possession of it. And if that's the case, then if the jury decided that there was not a tether strap on the ATV at the time they took possession of it, then Richie is potentially liable under the theory of negligence and under the Tennessee Products Liability Act, because a tether strap should have been on there. There's no, it's unquestioned that it came with that, and it would be a modification made by the seller. As to the owner's manual and safety instructions, all three plaintiffs testified that they never received an owner's manual. That was affirmative testimony. Neither Packlib nor Coker could say whether there was an owner's manual at the time they took possession of it. Richie's own document, this pre-delivery inspection form, has a box in there to check that they were provided an owner's manual, and that box is not checked. And Ms. Coker testified that if she'd done those things, she would have checked the box. There's certainly an issue of fact as whether they received an owner's manual. There was no finding by the trial court as to whether any safety instructions were provided. The plaintiffs testified that they did not receive any safety instructions. The pre-delivery inspection form, again, is not checked off as to that being done. Certainly an issue of fact on that. Turning quickly to the defendant Polaris, the trial court found that it did not have a duty, that Polaris did not have a duty to install a rubber stopper as a safety device on the type of winch at issue in this litigation. The record demonstrates that Polaris had installed such devices on other ATVs to prevent these type of injuries. The record demonstrates that the plaintiffs had purchased other ATVs that used rubber stops as a safety mechanism. Both Mr. Vaulton, that's senior, Barry Vaulton, and Ms. Coker testified that rubber stoppers were safety devices designed to prevent the winch hook from going into the roller, and that this would have prevented this type of injury. Mr. Vaulton is very, very experienced in ATV ownership and has and the use of winches. There is no expert testimony to the contrary on that issue. Respectfully, the trial court failed to analyze, sufficiently analyze the idea of a duty in this situation, never making any, findings as to foreseeability or the gravity of harm or the burden to engage in alternative conduct. As far as foreseeability goes, the fact that there are warnings regarding this and that Polaris trumpets these warnings in their response shows how foreseeable this injury was. Finally, and next, I guess, the trial court determined that, and this is quoting, there is no evidence in the record that the winch cable was misspooled or reverse spooled. And respectfully, that's nonsense. Barry and Sam Vaulton both described the reverse spooling. Sam Vaulton described it at the time of the incident that he told his friend to push the out button. When he did, it went in. And it gets a little more gruesome there later on in that day, that same day. Sam went to retrieve his finger, which was still stuck in the winch, and again had someone and again pushed the out button, and it went in again. And the next day, Barry Vaulton tested the winch controls, and again, when he pushed the out button, it went in. That is clear evidence of reverse spooling happening in this case. Mr. Packlip testified, and they suggest that he didn't testify that it was his opinion that reverse spooling occurred in this case, but that's exactly what he said. He said in his deposition that it went reverse on the spool, and now the in is out and the out is in. It wasn't speculation on his part. He took part in this inspection in November of 2018. He had a sufficient opportunity to perceive what happened on that day. He also owns or has owned several, that owned a 2017 General and other ATVs. It's important to note that there is no expert testimony in this record from the defendants that reverse spooling did not occur. This winch came pre-assembled on the ATV and was never used before the day of the accident. That's what the record reflects. That is enough to create a jury question as to whether this device was dangerous and defective. Jury should decide whether the reverse spooling or propensity to reverse spool was a dangerous and defective condition. Juries to decide whether an ordinary consumer pressing the out control should result in the winch cable going out rather than whether that's a dangerous condition. Respectfully, the record is replete of testimony and evidence creating factual issues as to both Ritchie and Polaris's liability, and for that reason, trial court summary judgment order should be vacated.
Finish, counsel. What do you say there was the proof in there about the owner's manual and the DVD? I think the safety DVD that they weren't provided.
All three plaintiffs testified that they did not receive those.
Well, I mean, tell me exactly what they said. Did not receive them, or they didn't see them?
No, they said they didn't get an owner's manual. All three of them said there wasn't an owner's manual.
Do you ever see any warnings, any type guides or warning manuals? I don't remember. That's not the same as saying, I mean, that's what I'm asking is where.
You'll have to bear with me.
Yes, sir.
I apologize. And I believe that this is on page 23 of our opening brief. And it's the Vaulton testified that they never received an owner's manual, and it cites to volume 2 at 147, volume 2 at 249, volume 3 at 380, and volume 5 at 622.
Thank you. We'll check those ourselves. So thank you. You have your time for rebuttal.
Thank you, Your Honor.
We're here from the appellees, and I understand y'all agreed how you're going to divide your time.
Yes, sir. This is Lucas Jerkins on behalf of Ritchie Power Sports and the appellee, of course. And yes, me and attorney Mr. Schneider for Polaris have decided that he would take 10 minutes and I would take 5 due to the issues presented before the court.
Thank you.
Okay. Thank you, Your Honor. And Your Honor, we submit that the trial court properly found that the plaintiff had failed to demonstrate the that there was evidence at the summary judgment stage that was, sufficient to continue their claim or defense according to Rye versus Women's Care. And Your Honor, this is a products liability, or Your Honor, excuse me, this is a products liability claim. The plaintiff admits it from the outset, and at no point in the summary judgment stage did plaintiff's counsel, or the appellant in this case, submit that this is a claim under TPLA, or even provide that there was any sort of alteration or modification language. The first time we get this alteration or modification language as required by the Tennessee, by the TPLA, is when we got to the reply in the appeals court. Now the TCA, as you know, 29-28-102, the only space, the only exception that the plaintiffs or the appellants would have in this would be an alteration or modification of the product. Now, there's nothing in front of you other than a citation in the reply to Black's Law Dictionary as to what Tennessee, well, even if that, would be an alteration or modification of the Polaris General. Now, obviously, for the purposes of summary judgment, everything that the appellants are relying on is testimony from the Vaultons, that they haven't gone out and gotten any other means, affidavit, or anything to corroborate at least what is against the appellees, Ritchie Power Sports. Your Honors, if it pleases the court, the facts are that Ruben Packlib is the mechanic for Ritchie Power Sports, and he's gold certified through Polaris to work on their vehicles. Mr. Packlib testified that the winch, which is the only portion of the Polaris General that's in dispute in this matter, was pre-assembled by the manufacturer. Mr. Packlib testified the winch is not something he lays his hands on at all. Mr. Packlib further testified that every Polaris General that he has dealt with the exception of high lifters, come with a tether strap. He has not come across one that hasn't had a tether strap that needed to have one. Mr. Packlib.
So he says it comes with a tether strap. The plaintiffs say, well, there wasn't one there. Isn't that a issue for the jury?
Your Honor, I would submit that, and Judge Bennett, it's a great question. What I would submit to you is the fact that Mr. Packlib is to say that it comes on it. If it's there and the manufacturer put it on, they don't mess with it. They don't touch it. Now the Vaultons come through and they buy the Polaris and they leave on December 3rd. And Mr. Vaulton says that he doesn't notice it. It's not that he said it wasn't there. And in fact, he says that he would have made he would not have left the dealership had he noticed the tether strap was not there. So what we have here is we have Mr. Packlib with years upon years of experience saying that he's never seen one come that does not have it. It's pre-manufactured. So we would submit, even though there's no evidence to this point, that if it wasn't on there, it came pre-manufactured. Now there's no dispute from plaintiff that the manufacturer failed to put the tether strap on. It's only against Ritchie. But what we can show is that Mr. Packlib said it was there. He doesn't put hands on the winch. And Mr. Vaulton.
Well, does he say it's there, or does he say I don't have it? I don't do anything with the winch? I mean,
he says I don't do anything with the
I don't
winch.
do anything with the winch, but it was there.
He says he hasn't. It would be unusual, I believe is how he said it. It would be unusual for him to see one that wasn't on there because he sees them all the time and they have the tether straps except for the high lifters. What we're also talking about is, this is pre-assembled, so he doesn't touch it whatsoever. And Mr. Vaulton comes in, takes possession of it, says he never saw it. 3 months later, the testimony is they don't see it on the Polaris at the time of the accident. All that testimony that's in the record that's cited to by the appellants is actually their testimony from 3 months later. Everything before that, they say, we just didn't notice it. So
is it the same with the manual?
Yes, Your Honor, and you're right on it. You're great segue there for us. The manual, they say, was not there. Now they cite to a pre-delivery inspection where it wasn't checked off by Lacey Coker that the manual was given. However, the keys were given to him, and if the keys hadn't been received, they wouldn't have had this accident you could dispute, but they did receive the keys. So therefore, the pre-delivery inspection is not something that we can really look at and say definitively this is what happened. Further, there's testimony from Ruben Packlib and 3 affidavits from Polaris inspectors and the appellant's own videographer that says upon the inspections, the user manuals were there. And there's been no allegation that either one of the defendants, especially Richard Power Sports, planted this information during the investigation. Your Honor, I know I've run out of time, Your Honors. Pursuant to Rye versus Women's Care Center, summary judgment was appropriately granted for the appellee, and we would appreciate you, we would submit that it should be affirmed.
Thank you. Mr. Snyder. I'm sorry, who do we have next?
That'd be me.
Yes,
Your
sir.
Honor. This is
Go ahead.
Mike Snyder.
Yes. Go ahead, counsel.
Thank you. Good afternoon, Your Honors. May it please the court, I'm Mike Snyder. I'm here on behalf of Polaris, along with my co-counsel, Bill Johnson, who will not be speaking today. We're grateful for the time. At this point, I'd like to incorporate the record evidence and the previous briefing into my argument here. From Polaris' perspective, this case is actually fairly straightforward. There are 2 issues that are left that involve Polaris. Number 1, whether the winch was defective or unreasonably dangerous at the time that it left Polaris's custody and control. I think that's a focal point that I'll be raising throughout my argument today. And 2, whether Polaris had an affirmative duty to include a rubber stopper at the end of the winch. As the trial court correctly found, and as I will show through supporting testimony and evidence today, the answer to both questions as a matter of law is that no, they did not have that duty, and no, there was no unreasonably dangerous or defective condition existing at the time the winch left Polaris's custody. Before going directly into those questions, there are 2 issues that I think are very important for this court to remember as it makes its considerations. The vehicle had been outside of Polaris's possession, custody, and control for a very significant period of time prior to the incident. It was in Richie's Power Sports possession in August of 2016. It was sold to the Vaultons on November 2016, and this incident occurred then in March of 2017. Plaintiffs testified unequivocally that in the 3 months between the time they took possession of it from Richie Power Sports, they were using the Ranger at least 5 times per week, which means the Ranger had been used approximately 60 to 75 times conservatively prior to the accident without anyone noticing any alleged problem with the winch, without anyone noticing any type of issue that a tether was missing, without anything. And going back to your question, that
what was the proof as to this? What the proof that this was the first time the winch had been used?
The testimony by Barry Vaulton and by Sam Vaulton was that, to their knowledge, this was the first time that it was used. They did not proffer any testimony of any of their other employees or other people that may have used it, which we know, at least subsequent to the incident, that numerous other employees used it. But that was their testimony, that nobody used it. But yet we know that that's inaccurate. And if I could proffer that, I would like to share that with you. We know that that's incorrect because, number one, when it got to Richie Power Sports, and I agree with Mr. Jerkins that while Mr. Packleb didn't say that he put on the winch, he did testify under oath that he had never seen a time when it had not been delivered with a tether. So that's number one. Nobody saw anything wrong at the time it arrived. So right there, we have a situation where there's no indicia no indications or issues that anybody saw. Was there?
So the seller says, nope, not us, because we didn't touch it or look at it. The manufacturer says, well, the seller had it for a long time and they didn't see any problem with it. I mean, I'm having trouble. I will tell you, I'm having a little trouble squaring your position here. How for summary judgment purposes, that's when this went off, wasn't it?
Right. Thank you, Your Honor.
Summary judgment purposes. Why is there not a dispute? And let me just kind of cut to it before we get too further in. Why is there not a legitimate dispute of whether or not, when the out button was pushed, the cable went in?
First of all, under Tennessee law, the plaintiffs are required to demonstrate that there was a defect at the time it left our position, custody, and control.
All right, and the proof, at least for summary judgment purposes,
right,
is this may not turn out to be at all if it goes to trial. First time the winch is used, the out button is pushed, it goes in reverse. I mean, why doesn't that create a genuine issue of whether or not when the out button was pushed, it went into reverse the first time it was used for summary judgment?
For several reasons, not only what I just said, but also for the fact that here it was several months later, and we know that it had to have been used in some way, because Sam Vaulton himself testified that the hook had been pulled in to the rollers. He said that was the first time he'd seen it. He hadn't noticed that before. He thought it was strange. It wasn't how it had been in the operation he'd been doing it. So how did it get there? There was no tether. So not only was there no tether, which he would have been holding on to the tether if the tether had been there. So we know it had been used or misused or abused it somehow. Then on top of it, the winch hook was in a different condition than at any time in the previous 3 months that he'd been driving it, Your Honor. So for the very first time, the winch hook had been pulled in. He noticed it had been pulled in and said he wanted to put it the way it was supposed to be. So he puts his finger on it to pull it out. That's why we know, Your Honor, that it had been used. Now, they say that they didn't use it, but they didn't say nobody else had used it. They said they don't know of anybody using it. They didn't use it. So they would have to demonstrate that not only did nobody else use it, but then how did the tether get lost? When we have Sam and Barry under the testimony in their deposition saying they didn't see any reverse spooling, they didn't see any bunching, they didn't see any of that at any time prior to this event. So, Your Honor, I think for purposes of summary judgment, they can't meet their burden, not only of not showing it was defective at the time that it was received by Ritchie Power Sports, but it wasn't the same condition when it was received, when it was involved in the incident of that day. Next, there's allegations that, reverse spooling, going back to what you were saying, Your Honor, that reverse spooling somehow is a defect. Reverse spooling can happen on any product that's been abused or misused. A winch consists of a drum or a cylinder, and as the line goes out, the hook at the end of the line and the tether on the hook is there. Plaintiffs claim that the winch was misspooled at the time of the accident, but the fact that a winch can reverse spool isn't a defect. That's why there's clear safety warnings and user instructions on how to use these winches, which were not followed by this appellant. Plaintiffs haven't even claimed that if a winch misspools, it's a defect. In fact, the plaintiffs agree that under Tennessee law, the question is whether the defect or unsafe condition was present when it left possession of Polaris. And that's an appellant's opposition brief at page 27 and page 29. Now, I want to talk for a minute, because I have short time, on the second issue. which was whether Polaris had an affirmative duty to include a rubber stopper. There is no admissible evidence that that this is a safety feature at all, let alone that Polaris had a duty to incorporate it into the winch. Barry Vaulton's testimony states very clearly that he didn't know, he didn't even know what it was. He did no research, but he thinks that's what it was. He thought that might be. He does not qualify to provide lay opinion testimony under the Tennessee rules. And under cross-examination, he said he didn't even know what it was. Sam Vaulton didn't know what it was. Then their reliance on Lacey Coker Lavon. If you look at her testimony, and that's found at pages 944 of the transcript through about 15 other pages, she's talking about a totally different winch. She's talking about a totally different stopping mechanism. It isn't this one. And so they're completely in opposite. They do not provide any admissible testimony here. And Barry Packleb says unequivocally, repeatedly, this was not a safety. This was not for safety. It's to keep the hook in place. So any testimony to the contrary is not admissible given the lay of the land, because it has to be done, as the court knows, based on factual and firsthand knowledge, which Barry Vaulton nor Sam had. For these reasons, we would ask that this court sustain and affirm the summary judgment motion below, the court's order granting summary judgment in Polaris's favor below. Thank you.
And counsel, we'll hear from the appellant rebuttal.
Briefly, first, talking about Richie, even Polaris on page 2 of their response brief acknowledges that the plaintiffs brought a strict liability case against Richie. In our brief, in our reply brief, we cite this court to a decision in Young versus Reliance Electric Company, 584 Southwest 2nd, 663, Tennessee Court of Appeals, 1979, which stands for the proposition that the absence of a statement accompanying the product, which in some way informs a user of danger, may make the product defective or unreasonably dangerous. Thus, the failure to provide the owner's manual potentially renders it defective and unreasonably dangerous.
Counsel,
Yes.
how is there a genuine issue, without weighing the evidence, but how is there a genuine issue from what your clients say and the fact that the owner's manual was found in the glove compartment?
Your Honor, I think
a genuine issue.
And that's a tough one from our perspective, Your Honor. And it hasn't been fully developed, but the issue is on that is that this inspection, the 2 inspections occurred 20 months and 28 months after this incident. And while it may be evidence that the owner manual was in place in the glove compartment in December of 2016 when they took possession of it, that's a jury question to decide whether something that was photographed or found 20 or 28 months after the fact and is documented as being in there somehow discounts what the plaintiffs have said about the owner's manual.
Was in your client's possession. The vehicle was in your client's possession that time.
Yes, it was, Your Honor. There's no question about that. But respectfully, I do think it's a jury question for the jury to decide that issue. Respectfully, you may not like that, but I do think it is a jury question. Turning to, again, Mr. Jerkins talked a lot about whether something is definitive or whether we need to provide corroboration. That's weighing the evidence. And we've created issues of fact here on all 4 theories here. In fact, Mr. Snyder talked with regard to Polaris about somebody's testimony being inaccurate. Again, that goes to the credibility, and that is weighing the evidence. That is for the jury to decide in this case. There are issues of fact on all 4 of these issues that need to be resolved by a jury, and were not properly disposed of upon summary judgment. And Mr. Snyder made a very nice closing argument as to why these things, the facts can't be as we say they are. But that's exactly what it was. It was closing argument. Talked about abuse and misuse, and it just can't be this way. That's closing argument, and it's for the jury to decide those issues. So respectfully, this court ought to reverse the trial court, send this case back, and have this case tried on all four theories. If you have any other questions, I'll be happy to answer.
I hear none, counsel. The court's thanks to all counsel for your briefs and your oral arguments. I think you all have made your positions on the issues very clear to the court. So thank you very much for that. If you would please recess court till tomorrow morning.
This honorable court stands adjourned.
Thank you.